there any objection? There is no objection. I call John Boscowan.
Thank you, Mr Chair. We're debating, of course, the Regulatory Improvement Bill, and this bill makes a number of amendments to a number of acts. And Stuart Nash outlined them earlier this morning. And there is, of course, the Companies Act, the Conservation Act, the Fisheries Act, the Gas Act, the Hazardous Substance and New Organisms Act. But, Mr Chair, I want to focus my comments on two particular acts, and they are, sir, the Design Act, and they are the Ministry of Agriculture and Fisheries Restructuring Act 1995. Sir, referring first to the Design Act, we note in the commentary that this bill, this Regulatory Improvement Bill, has been drafted to come into effect the day after it's given the royal assent, with exception, sir, to most of the provisions changes to the Design Act 1953. And when this bill first came into the House, there was a provision there for the changes to the Design Act 1953 to become effective on the date of being made Order in Council, or the date that the Governor-General gave the royal assent. And of course there was no fixed time for that. That could have dragged on for a number of years. In fact, we heard a member of the Labour opposition mention this morning one particular instance where it took some 8 years for a particular act to come into force, or regulations to come into force. And so the committee, the Commerce Committee, of which I'm a member, I have to say I didn't play a large part in this particular bill's deliberation, but nevertheless a member. The committee was concerned to ensure there was some certainty, and so an amendment was made, and the Labour Party speakers this morning have spoken on this at length, and there was a provision there, Mr Speaker, where notwithstanding the balance of the bills, all the other changes were coming in immediately. With respect to the Design Act, the changes to the Design Act were to come into effect essentially on the earlier of two dates. The earlier of the royal assent, or the Governor-General giving an Order in Council, or 1 year after this particular bill is passed. And the reason for making that was to provide certainty. And in the commentary, the Select Committee have said that members of the public need to have certainty, and there should only be very rare and exceptional circumstances when we don't provide that certainty, only rare and exceptional circumstances where it's justifiable to not have some certainty and not actually set down a date for the provisions to come into effect. And, sir, Mr Speaker, that actually set my mind thinking, when else would you have those rare and exceptional circumstances? And my mind, sir, passed back to the passing of the Emissions Trading Bill last November. And of course we were told by this House that the Emissions Trading Bill was to be based on the Australian scheme, and that the officials could make all the regulations they wanted, and that they would have more than sufficient time, because all they had to do was to copy the Australian regulations. Well, Mr Speaker, I realise you want me to keep the debate to the particular issue of the Design Act, and I guess the point I'm making is that the Design Act deals with copyright, it deals with designs, and it was considered that a year should be more than sufficient time to make those regulations. And that's not surprising that a year should be sufficient, sir, because the regulations that were to flow from the emissions trading scheme all had to get made in 6 months. Shouldn't have been a problem because we were copying the Australian legislation. No. Only problem, there's no Australian legislation. No Australian legislation at all, and of course we're going where no country's gone before. Mr Speaker, that leads me on to the next point, if I could just find my notes. The Fisheries... The Ministry of Agriculture and Fisheries Restructuring Act 1995. And so this Regulatory Improvement Bill makes some amendments to the Ministry of Agriculture and Fisheries Restructuring Act 1995. And so the primary purpose of those amendments is to remove the penalty regimes applicable under that Act. To remove the penalty regimes applicable under the Act for non-payment of cost recovery levies as they're already provided in the Fisheries Act 1996. So what we're doing here, sir, is we are making amendments to the Ministry of Agriculture and Fisheries Restructuring Act 1995 to essentially ensure there's not a duplication of penalties. That if fishermen... Mr Chair?
The Honourable Rodney Hyde.
Thank you, Mr Speaker.